Hey y'all, Rob here with ATX.legal. Today I'm going to talk to you a little bit about juvenile law. But first, let's get the disclaimer out of the way. It's not legal advice. This is not advice for your specific situation. If you do want advice for your situation, just visit us at ATX.legal. So, juvenile law is exactly like adult law, except it's completely different. So you're going to see a lot of the same kind of concepts with completely different terms. So for example, a respondent is the defendant, a plea of true instead of a plea of guilty, a directive to apprehend instead of a warrant. These things mean basically the same thing, but it's a whole different code. It's controlled by the family code and the criminal code kind of together. So it does create kind of a whole new sort of world for attorneys. So you do want to make sure that your attorney knows about juvenile law, specifically when you do hire them. So just in a general basis, juvenile law is more lenient than criminal law. So you would rather be in the juvenile system than the criminal system. They're focused more on rehabilitation rather than punishment. So there are a lot of times when, if a crime is committed in the adult world, that person might get jail time or a more severe sentence, but in the juvenile world, the punishment will be less severe. Now, the same kind of crimes that apply to adults also apply to juveniles, and it's the same elements for those crimes. Juveniles also have delinquent conduct, which is stuff like truancy or running away, that's in addition to the criminal code, and those aren't technically crimes, but they are handled in the juvenile justice system. Now, let's first talk about age. So a child means anything between the ages of 10 and 17. If they're younger than 10, they cannot be charged with a crime. It's handled differently. It's going to be handled with therapy, something else, but they do not enter the juvenile justice system if they're under the age of 10. If the alleged charge is committed after the 17th birthday, then they're going to be transferred to adult court. If 15 or 16, the prosecutor can apply to transfer them to juvenile court. That does not typically happen in Travis County, certifying as an adult. It's very, very rare. It does happen occasionally, maybe a few times a year on very, very serious charges. But for the most part, in Travis County, the prosecutor is not going to look to certify as an adult. Okay, so the first way that juvenile court is very different from adult court is with the detention hearing. So in adult court, you have things like bail, and you can go through a bondsman to get released, but there's none of that in juvenile court. Instead, a judge makes the determination whether the child will go home with a detention hearing. So the detention hearing will be scheduled as soon as possible, within 24 hours. That math can change on the weekend or on holidays, but usually, if not the same day, it will be the next day when a detention hearing happens. Now, at the detention hearing, the judge must determine a few things in order to keep the child in custody if that's what she wants to do. She must find probable cause, and in addition to probable cause, the child still must be released unless he is likely to abscond, there's no suitable care provided at home, or if there's just not a parent or guardian to return him to, or if he might be a danger to himself or others. And if the judge determines that there is a safe place, the judge will release the child, but if not, the judge can hold the child for up to 2 weeks, and there will be continuing detention hearings every 2 weeks until the child is released. If the child is released from the detention hearing, the judge can put on conditions of release. These conditions can be anything reasonably necessary to ensure the child's appearance later in court. So the judge can get creative on this. There's not really much of a restriction on what the judge can impose on the child, but there are some common ones. So a curfew is very common. Sometimes in-home detention can only leave house with the parents. If their parents aren't always home, an ankle monitor to ensure that they're going to be at home. Family therapy is common, and every child, once they're in the system, they're going to be assigned a probation officer. It sounds like they're on probation, but they're not. They're on pretrial, but they're still assigned a probation officer. And that probation officer will just assure that the child is complying with these conditions. They'll meet with the family, meet with the child, and there will be check-ins to make sure that everything is going smoothly. It's a really good idea to maintain a positive relationship with the PO. That goes for the children and the parents. because the PO is going to bring their input into court. So their opinion as a neutral party is going to be taken to heart by the judge a lot, and they're going to believe the PO ahead of the prosecutor or the defense. So maintaining a good relationship with them is a good idea. All right, now let's talk about punishment for juvenile cases. Punishment is going to be across the board more lenient than criminal cases. It just is. So for misdemeanors, the punishment is almost always probation at home. But probation in the juvenile court is different than probation in adult court. You do need to check in, but there are no fees. And then there are going to be programs that they set you up with that are usually designed to help the family and help the dynamic as opposed to punish. Part of probation at home is going to include making sure you attend school, community service hours, and if things aren't going smoothly, the probation officer is going to report to court that there are violations, and we can come back to court and have a motion to modify the probation, add conditions, do things like that. But for the most part, probation at home is not too severe, other than just reporting to the probation officer and just keeping things on track. A step up from probation at home is something called placement. Placement is also technically probation, but it definitely feels like jail time. So the child would be in custody for a time. Usually it's a shorter time period, maybe 2, 3, 4 months. And during that time, if they do well in custody, if they are maintaining what are called levels, which means they're given a level every day, and if they maintain high levels, oftentimes they're going to be released early to probation at home. So it definitely feels like jail time. It is basically jail time, but it's technically probation, and they could be released early if they do well. This can be in a secure or non-secure facility. Non-secure facilities tend to be more informal. There's not like jail cells, but they're not free to leave. It can be up to a year, but like I said, they'll often be released after 3 or 4 months if they're doing well. The next step up is going to be what's called a determinate sentence. And this is really for felonies only, and it's rare in Travis County, but it does happen. Prosecutors have to give notice that they're going to be seeking a determinate sentence. Once they do that, it kind of ups the ante for the whole case. Everything's taken a little more seriously because now we have the possibility of a real jail term. And that jail term, if they turn 19, they can actually be transferred to the adult court if they're still serving out their determinate sentence. So if you hear that word that prosecutors have filed notice that they're seeking a determinate sentence in the case, just be aware that ups the seriousness of the whole proceedings. Now, restitution is kind of a separate issue, but it often becomes a factor in juvenile cases. Just keep in mind restitution, and what restitution is money that you would pay to the alleged victims for what they've lost. Oftentimes, you're looking at damage to a vehicle or other property damage. And if the juvenile can't pay, it is the responsibility of the parents to also make payments. So oftentimes it's limited to the insurance copay. A very common amount is $500 because that's where a lot of insurance copay is set. There is a program called Pot of Gold where the child can earn money as part of their community service hours, and then that money gets paid to the restitution. And I want to add a quick note about juveniles. As criminals, they don't tend to be very good criminals. Usually these cases are pretty open and shut. They're not good at covering their tracks. There are exceptions, but usually the negotiation happens with the prosecutors as far as levels of punishment and not exactly with the crime itself, which is usually there's ample evidence for it. But anyway, moving to juvenile records are very different from adult records. They're handled under a completely different scheme. And not only that, they completely changed in 2017 when the legislature put in some rules that tried to make it better on juveniles, and in some ways it did, and other ways it really didn't. But now juvenile records cannot be expunged, which means the records are destroyed. Instead, they can only be sealed. But in general, the general public doesn't get to view juvenile records ever, even before they're sealed. And then once they're sealed, you have court authorities who are able to look at the records, but never the general public. If a juvenile is asked about his juvenile record on a job employment or college application, he does not have to admit guilt in those scenarios. Once the child turns 19, the record is automatically sealed. And you might be asking, if you know a little bit about records, well, if the general public can't see it, then what does it mean to be sealed? Well, in this case, the court cuts off access to it, but they still maintain the records. So very limited people would still be able to see those records. Now, there are some exceptions. If the child still has a pending juvenile case, or if they have a pending adult case, those records do not get sealed. And so what that means is the prosecutors in the new case, in the adult case, will be able to see these records, and they can and do hold these records against the child. So before 2017, there were scenarios when the juvenile could get those records expunged. Now, they would have to hire an attorney and go through the process of getting it expunged, and now that process happens automatically, but the records don't get destroyed, they get sealed. So it's kind of that give and take where, what do you want? But you would think, personally, I would think that the expunction would make more sense in the case of juvenile records, because these things are happening before the child's brain is fully formed. They're making mistakes that they're not going to make later in life, so we don't want to hold that against them. But that's the way the law is written. So I hope this answered some of your questions about juvenile law. If you're a parent and you have a child who's been charged, it can be very stressful, feel free to give me a call and we can talk about the case. Your child will be assigned an attorney. Every juvenile gets an attorney unless you don't qualify financially, in which case you'll have to hire someone. But just keep in mind that when your child gets an attorney, that attorney is representing them, not you. So there have been rare but a few instances where the interests of the child do not align with the interests of the parent. And in that case, the attorney is always going to have to listen to the child and look out for the child's interests, even when they conflict with the parents. But that said, it often becomes a very collaborative process. Usually the interests are aligned, and it goes pretty smoothly, but just something to keep in mind. Anyway, thank you for watching, and good luck with your case.